Good morning and welcome everyone. Thank you very much for joining us today. My name is Sarah Clarke and I am a member of the Employment and Discrimination team at 3PB. I am joined today by my colleague Grace Nicholls, and we're going to be talking today about personal injury claims arising out of discrimination. I'm going to briefly touch on the jurisdiction of the Tribunal and the legal test to be applied. Grace is then going to talk about the interplay between personal injury claims and claims for other non-pecuniary damages, namely injury to feelings and aggravated damages. We will then touch on some of the practical issues, such as medical evidence, contributory faults and apportionment. And lastly, we will touch on factors to consider when deciding whether or not to bring these claims in the County Court or the Employment Tribunal. Now, you should all be able to see a Q&A box at the bottom of your screen. If you do have any questions, please type them in for us, and we will try to cover these at the end. However, it might not be possible to deal with all of them. Also, if you have any questions of a technical nature, please also type them into this box. Today's talk is being recorded and shall be sent out in due course. So back to basics. What does the Equality Act say about claims for discrimination and compensation? Well, Section 124 and 119 say that damages for discrimination are the same as those as can be recovered for tort. Now, the Equality Act doesn't make any specific reference to the ability of the Tribunal to deal with a claim for personal injury, but it is now long established, following the Court of Appeal case in Sheriff and Klein Tugs, that the Employment Tribunal does have such jurisdiction. So, what is the basis for such damages? Well, in tort, one has to put the person in the same position they would have been in had the tort not occurred. So what then is the test to be applied in terms of causation? Well, in most tort claims, the question is whether or not the damages were reasonably foreseeable. In other words, would the damage being claimed have been foreseen by someone with the defendant's knowledge and experience? Now, there are some exceptions to that, such as deceit and defamation. Now, this issue was considered by the Court of Appeal in Essa and Lang 2004. Mr. Essa worked as a construction worker at the Millennium Stadium in Cardiff. He was of Black Somali origin, and he was subject to various acts of race discrimination. In particular, on one occasion, the foreman said of him, "Make sure that black cunt doesn't wander off," and this remark caused him immense distress. He resigned and brought a claim for race discrimination. Now, the tribunal found that he had undergone a dramatic personality change and suffered depression as a result of this. He stopped looking for work and was claiming, therefore, for his ongoing loss of earnings. However, the tribunal found that the employer was only liable for such reasonably foreseeable loss as was directly caused by the discriminating act, and that whilst the respondent might have reasonably foreseen that some distress would have been caused, they could not reasonably have foreseen the extent of his reaction. They therefore limited losses to 3 weeks of earnings. Now, the matter got up to the Court of Appeal, and they disagreed with the approach of the tribunal. They find that one is entitled to be compensated for the loss which arises naturally and directly from the wrong, and that all that needed to be shown was that the discrimination was the cause of the injury. Thus, the usual rules in respect of tortious claims was found not to apply. Now, Lord Justice Pill had found that in torts such as negligence and nuisance, the need to establish foreseeability was necessary in order to do justice, as it would be unfair to hold a party to account for unforeseeable loss. There was reference back to the case of the Wagamount, which you may recall from your law school days. However, he distinguished these types of cases, saying it was very different where you had direct racial abuse, which he likened to torts of assault and battery, in that there was deliberate conduct. Now, he did go on to say that it was possible that where the discrimination takes other forms, different considerations may apply, but he didn't elaborate on this point. So therefore, it left the door open to treating different types of discrimination, such as indirect discrimination, differently. And this approach was bolstered by the EAT in the case of Abbey National and Jagger of 2009. And what Underhill there said was that there is nothing in the statute to suggest that discrimination is to be treated as a specially heinous wrong to which special rules of compensation should apply, which is effectively what occurred in ESSA. It was pointed out that in ESSA, the Court of Appeal did recognise the distinction between overt discrimination and other forms. Therefore, it seems that this decision really leaves open the door that the test of reasonable foreseeability might apply in cases of indirect discrimination or failure to make reasonable adjustments. Now I'm going to hand over to Grace now, and she is going to go through how damages for personal injury interplays with other forms of non-pecuniary loss.
Thanks very much, Sarah. So I'm going to talk to you, as Sarah said, about the interplay between PI and injury to feelings in particular, but also in the case of aggravated damages. The first and probably the most important case to deal with on this topic is HM Prison Service in Salmon, which is a 2001 EAT case, also interestingly heard by Underhill. Mrs. Salmon, a former prison officer, brought claims for sex discrimination. An incident took place in October 1996, which was referred to as the Doc Book incident, which resulted in the claimant going off sick, later being diagnosed with a moderate to severe depressive illness, and she took medical retirement a year later in December 1997. No appeal was made against the factual findings of the Ashford Employment Tribunal, and a remedy hearing took place over 4 days in 1999, the original liability decision having been heard at the end of 1997 and into early 1998. At the remedy hearing, the tribunal heard evidence from the claimant and 2 consultant psychiatrists who examined her, one who was called by the claimant, Dr. Jarman, and one who was called by the prison service, Dr. Turner. It was agreed by the experts that since October 1996, the claimant had been suffering from a major depressive disorder, and that she'd experienced episodes of extreme depression and thoughts of suicide. The following awards were made by the tribunal. Firstly, in respect of general damages, the tribunal awarded the claimant £11,250 as compensation for the psychiatric damage. That is in respect of the depressive illness that the claimant was suffering from. They arrived at that figure by assessing full compensation at £15,000 and then reducing the figure down by 25% on the basis that the illness was only caused to the extent of 75% by the acts of discrimination which it had found. In respect of injury to feelings, the tribunal awarded Mrs. Salmon £20,000 and a further £45,000 in terms of loss of earnings. The prison service appealed to the EAT against all of the assessments of each of those heads of damage, but of course we're looking here in particular at the psychiatric injury and the injury to feelings. Turning to the relationship between those 2 awards, the EAT discerned as follows. In practice, the 2 types of injuries are not always easily separable. In a given case, it may be impossible to say with any certainty or precision when the distress and humiliation that may be inflicted on the victim of a discrimination becomes a recognised psychiatric illness such as depression. Injury to feeling can cover a very wide range. At the lower end are comparatively minor instances of upset or distress, typically caused by one-off acts or episodes of discrimination. But at the upper end, it's likely to be serious and prolonged feelings of humiliation, low self-esteem and depression. And in these cases, it may be fairly arbitrary whether the symptoms are put forward to the tribunal as a psychiatric illness, supported by formal diagnosis and expert evidence. The EAT went on to say that where separate awards are made, the tribunal must be alert to the risk that what is essentially the same suffering may be compensated twice under different heads. The question in this case is whether such double counting, i.e. between injury to feelings and personal injury, had occurred. The EAT said that they'd not found this easy. The tribunal had not explicitly addressed the question of the relationship between the 2 heads of damage. It was on the face surprising that Mrs. Salmon had received £20,000 for injury to feelings and only £11,250 for psychiatric injury. Intuitively, a fairly severe depressive illness ought to attract a higher award than mere injury to feelings, however great. But this apparent mismatch may itself reflect the artificiality of trying to divide Mrs. Salmon's injuries into 2 separate boxes. It may well be that the tribunal included injury to feeling elements that could have been included in general damages, in respect of which it's awarded was actually not overly generous. The tribunal had said that they considered it to be on perhaps low side. The EAT said that it's necessary to stand back and consider the non-pecuniary award as a whole. In their judgment, if one considered the totality of Mrs. Salmon's suffering from the point of the first unlawful acts of discrimination through the immediate impact of the DocBook incident and into the prolonged depressive illness which followed, a total award of over £31,000 could not be described as wholly excessive, even taking into account the deduction. In light of that, the EAT declined to interfere with the award of £20,000 under the head of injury to feelings. The Court of Appeal reiterated the importance of taking into account overlap between individual heads of damage in Vento and Chief Constable of West Yorkshire Police No. 2, a case which I'm sure we are all very familiar with. In that case, the Court of Appeal made it clear that common sense requires that regard should be had to the overall magnitude of the sum of the total awards of compensation for non-pecuniary loss made under the various headings of injury to feelings, psychiatric damage, and aggravated damage. In particular, double recovery should be avoided by taking appropriate account of the overlap between those individual heads. The extent of the overlap will depend on the facts of each particular case. So we know from that, very fact specific. In the case of Curden and Yorkshire Housing, an ET decision from 2008, the claimant commenced employment with the respondent through their predecessor as a customer services advisor in 2003. She resigned in December 2007 and brought claims of constructive unfair dismissal and failure to make reasonable adjustments. And she said that her employer had failed to make those reasonable adjustments in respect of her major depressive disorder, which manifests as severe variety and panic disorder with agoraphobia. The claimant's condition was exacerbated by such failure to make reasonable adjustments, and the tribunal awarded her £7,500 for psychiatric injury and £9,000 for injury to feelings. The tribunal stressed that it took great care to ensure there was no double recovery, clearly heeding the words of the higher courts. As in the case of aggravated damages and injury to feelings, a tribunal may but need not make separate awards for injury to feelings and personal injury. Turning briefly to aggravated damages and injury to feeling, in 2012, the case of the police of the Metropolis and Shore came before Mr. Justice Underhill, as he then was. He took the firm view that aggravated damages are an aspect of injury to feelings and should be considered as a subsection under the same head of loss to avoid double recovery. The EAT stressed, as it had done in Salmon, where of course he also heard the case, that the question which needed to be posed was whether the overall award was proportionate to the totality of the suffering. The final case I want to deal with is that of Base Children's Wear Limited in Oshady, which, when it was heard in the EAT, it was subsequently appealed to the Court of Appeal, but on a different issue. In that case, the claimant complained of various acts of race discrimination and was successful in demonstrating that one act and her dismissal were acts of racial harassment. She was awarded £16,000 for injury to feelings, £5,000 for aggravated damages, and £3,000 for depression for a period of 3 months. The EAT held that even though the unlawful discrimination related to an isolated event, her dismissal, this did not mean that it was required to assess the award for injury to feelings as falling within the lowest Vento bracket. The focus should be on the effect on the claimant, and the EAT should be astute not to allow double recovery for factors already taken into account under other heads. I think the key takeaway here is that where separate awards are made for injury to feelings and PI, a tribunal must be aware of not overcompensating the claimant twice. It's clearly an unenviable task to separate out distress and humiliation and morphing into a psychiatric illness, and it's clearly something practitioners will need to be aware of. Sarah, back to you.
Thank you, Grace. Okay, so I'm going to move on and talk a little bit about the evidence that is required. Now, obviously, the burden of proof is on the claimant to make out their claim, and they're going to need to show that the act of discrimination caused or materially contributed to the physical or psychological injury they are relying on. So how do they do that? Well, in the case of Sheriff and Klein tugs, it was suggested that it'd be very wise for claimants to get medical evidence. However, it is not actually strictly necessary, according to the EAT in Hampshire County Council and Wyatt 2016. Now, in that case, claims have been brought for unfair dismissal and disability discrimination. The claimant was a carer in a care home and was dyslexic, and she was invited to a meeting one day at which serious allegations were raised against her, and she was suspended. She was soon after signed off work with stress. Now, the investigation in the end didn't proceed, but she was eventually dismissed on capability grounds because of her ill health. Now, her claims were upheld. For example, it was found that the way in which that meeting was conducted was a failure to make reasonable adjustments because her employers had not properly and slowly explained the allegations to her, which impacted on her because of her dyslexia. And it was found that various acts caused or contributed to her depression. Now, she brought a claim for psychiatric illness, but she did not seek to rely on any medical evidence. However, the Employment Tribunal took the view that the claimant's own oral evidence about how she had suffered and the treatment that she had received was sufficient. They took the view that the judge could determine how bad the condition was and how long it was likely to take to resolve, and they awarded her £10,000. Now, the employer appealed this, arguing that the decision was perverse, where there was no expert medical evidence to support causation or the prognosis. And whilst the employer did concede that in a low-value claim, proportionality might drive parties to deal with such issues on a common sense basis, in a case of anything more than low value, they said expert evidence was required in order for there to be a proper analysis of the issues and causation. However, the EAT disagreed with this. Now, they accepted that in certain cases, there may be real difficulties for a tribunal trying to disentangle various issues to figure out what act led to what injury. For example, there might be non-work-related events that had an impact, such as marital problems or money issues. There might be situations on which medical views could differ on whether or not the psychological injury was divisible or indivisible, and Grace is going to touch more on this in due course. In such cases, the EAT said that medical evidence was advisable. However, they did not agree that there was any blanket rule that an award for personal injury could only be made with expert medical evidence. Now, in that case, they were quite alive to the various practical issues because the judgment here had only been received by the parties 1 month before the remedy hearing had been listed, and the medical evidence was only finalised the day before the remedy hearing. In those circumstances, the claimant was faced with the decision to go ahead with the hearing without the medical evidence because there was insufficient time for the respondent to consider it, or to go ahead without it. And that was clearly a factor which weighed heavily on the Employment Appeal Tribunal here. So whilst there is no hard and fast rule that expert medical evidence is required, which is unlike the situation in the county court, it would be somewhat foolhardy in a number of cases to not get such a report. If we're talking about a very low value claim, and by that I mean £2,000, £3,000, £4,000, and only say 1 or 2 acts of discrimination, then it really could be the case that you could say that the claimant's own evidence would be sufficient, especially if there were GP reports, occupational health records, which detailed the progression of her illness. Obviously, you need to bear in mind proportionality. Expert psychiatric reports can cost £1,000 or £2,000, and they're also going to involve a detailed examination of the individual. If you have a very low personal injury claim, do you really want to go to that expense? Also, as Grace has pointed out, the tribunal is going to be looking at the totality of the award. So in the more minor cases of psychiatric injury, you could simply argue it as part of the injury to feelings and argue that that should be increased because of course you don't need any medical evidence to bring a claim for injury to feelings. Now, obviously, if you have got a very high value complicated claim, so for example, if you have a situation where an individual has suffered from PTSD, which is going to have a lifelong impact on their ability to earn, such that you could have a claim worth hundreds of thousands of pounds or more, clearly it is going to be important to get medical evidence there. Also, you've got to bear in mind that in the big cases, you might have 20 or 30 acts of discrimination. Now, you're clearly going to have to try to figure out what specific acts that you can prove actually led or contributed to the injury that's being relied upon. Now, one thing to bear in mind is whether or not you simply hive off liability and remedy. Of course, if you lose your claim, there will be no need to get any medical evidence. Another advantage of this is, often it's the case that many discrimination claims are brought, but perhaps only a few are successful. If you wait until you have the judgment, then it's going to be easier to instruct an expert, because you can instruct the expert to comment only on the acts of discrimination which were proven. Whereas if you get the report prior to liability being established, you might have a situation in which an expert has considered a lot of acts which turn out not to be something which can be relied upon for such a claim. Now, if you do decide to get medical evidence, the question that's clearly going to come up is, do you go for a joint report or single experts? Now, in my experience, tribunals tend to want the parties to have a joint expert to save time and money. So if you want to get your own expert, you're going to generally have to persuade a tribunal as to why it is necessary. Now, of course, that's probably not going to be that difficult to do if you've got a very high value claim. But in the lower value claims, in my experience, it's going to be a joint expert. One thing to bear in mind when considering the best way forward is to look at the factors which are set out in the civil procedure rules as to when a single joint expert would be appropriate. That's set out in the practice direction to part 35. And there it's said that relevant factors to consider are things such as whether or not it's proportionate to have your own experts depending on the amount in dispute, the importance of the issues to the parties, and the complexity of the issue, and also whether or not the expert evidence falls within a substantially established area of knowledge which is unlikely to be in dispute. Of course, it's simply going to depend on what the case entails. In terms of valuing personal injury claims, the tribunal is going to be guided by the Judicial College guidelines, which provides brackets depending on the severity and duration of the injury. Now, some of the brackets are actually very wide. So, for example, moderate psychiatric damage range from £5,500 to £18,000, and moderately severe ranges from £18,000 to £51,000. Now, you might consider that if you're in front of a tribunal judge who perhaps isn't very familiar with dealing with these types of claims, you might actually want to get medical evidence on exactly whereabouts in that bracket the injury falls. Also helpful to try and find comparable cases if you can. For those of you who do PI, you'll no doubt be familiar with this in cases on places such as Kemp and Kemp. Obviously, it's important to remember if you do rely on those cases, it's difficult to find one on all fours, but especially in employment tribunal, it's going to hopefully assist the judge. Also remember that you can increase the value of those claims depending on inflation. And also you can add 10% on, which is what has been happening in PI claims since the case of Simmons and Castle. So now I'm going to move back to Grace, and she is going to deal with issues of contributory fault and failure to mitigate. Grace.
Thanks very much, Sarah. So yes, this is part 2 of the evidence, practicalities and valuation section. Dealing with this issue firstly about contributory conduct and failure to mitigate, the important case to note here is First Great Western and Wago, which is an EAT decision arising out of a claim that started at the Bristol Employment Tribunal. The nine appeal point agenda was whether the Law Reform Contributory Negligence Act of 1945, which I'll refer to as the 45 Act, could apply to some discrimination claims. The answer to that is yes. But reduction of any award for contributory negligence would be rarely, if ever, justified. So really important to note that whilst the Act might apply, it's incredibly rare that it will apply in practice. The claimant in this case commenced employment with the respondents. I've just got a note to say that the picture and sound quality is poor. Hopefully that should have resolved itself, but I'll keep an eye on it. In 2003 and remained in employment in 2018 when the case was heard before the EAT. Prior to going off sick, she was a customer services information controller. She brought numerous claims, including sex discrimination, victimisation, disability and race discrimination, covering 20 separate incidents. 2 acts of discrimination were proven after a 12-day hearing in February and March 2016. Those acts of discrimination were firstly a failure to make reasonable adjustments in relation to a delay in organising for the claimant to undergo CBT. And the second was a Section 15 complaint that the respondent had failed to consult with her over a 2-month period about reorganisation within her team because she was off sick. £22,000 was awarded for psychiatric injury in respect of the first finding, and £19,800 for injury to feelings also in respect of that first finding, plus an additional £26,000 in terms of loss of earnings. In relation to the failure to consult about the reorganisation, the claimant was awarded £8,800 for injury to feelings. As I said at the outset, 9 grounds of appeal were mounted by the respondents on appeal to the EAT, but ground 1 is the one that I want to focus in on, which was the issue of contributory negligence. The respondents sought to establish that the tribunal had erred in law in failing to make any deduction to reflect the claimant's contributory negligence, in failing to give to her employer details of a previous CBT therapy. The suggestion was that the claimant her previous provider of CBT. Therefore, the claimant failed to do so and was, the respondent said, contributory negligent as causative of some of the damages to the claimant, making a material contribution to the harm she suffered, and that they argued that a reduction ought to have been made and that the tribunal hadn't even considered the issue. The EAT made the following observations. There's no provision in the Equality Act for reducing the amount of compensation by reason of contributory fault, as there is in the unfair dismissal jurisdiction. Secondly, the amount of compensation for discrimination under the Equality Act corresponds to the amount that could be awarded by a county court, including for injury to feelings. And of course, this is something Sarah has just touched upon. Third, the wording of Section 1.1 of the 45 Act, on the face of it, can apply to some discrimination claims under the Equality Act. It is not restricted in its application and plainly applies where compensation for a tort is awarded in a county court. Lastly, the court said that the tribunal should be very wary of accepting invitations to reduce compensation for discriminatory acts by reason of contributory negligence under the 45 Act. And the EAT expected such cases would rarely, if ever, arise. And the reasons given were, for example, public policy reasons about not wanting to invite discussion about any contributory conduct in terms of discrimination. With the facts of this case in mind, the EAT commented that the contributory negligence might arise, for example, from a failure to keep an appointment with a medical expert for CBT. However, the EAT's view was that it would be better to treat such a case as a failure to mitigate a loss rather than to shoehorn it into the 1945 Act. The judge held that the ET did not overlook the contributory negligence argument, and even if it did, it would not have affected the result. Turning then to the second issue, which is a non-discriminatory reason in play. And the case here is Thane and LSE, where Mrs. Thane was employed as a painter and decorator and worked in the maintenance department. She brought claims for sex and disability discrimination together with unfair dismissal. Only 2 aspects of her claims for sexual discrimination survived, namely 2 claims of sexual harassment in respect of the presence of pornographic posters and magazines in her workplace, and a signing in book which kept on being moved to the men's changing room, which resulted in the claimant being subjected to sexist remarks when she went in to collect it. The tribunal found that the unlawful discrimination which the claimant had experienced had been material and effective cause of her ill health. The EAT noted that a number of factors had contributed to the claimant's ill health, including OCD and depressive episodes since 2003, the breakup of the claimant's relationship with her boyfriend, and concerns over her mother's health. These factors led the tribunal to conclude that her compensation had to be reduced to reflect the fact that they. Moreover, the tribunal noted that the consultant psychiatrist who'd been jointly instructed to prepare a report had commented that the claimant had exaggerated things and had been inconsistent. And indeed, this was a finding in terms of the exaggeration that the tribunal had found. That was the background against which the tribunal assessed the extent to which the unlawful discrimination should be contributed to her ill health at 40%. The EAT endorsed the approach of the tribunal. They held it would be unfair to expect an employer to compensate the claimant for her psychiatric ill health and consequences in their entirety, and given that the discrimination was only one of the material causative links. The next case I want to talk to you about is Bae Systems and Kozak, which is a 2017 case, which has a very, very long protracted history to it. The Court of Appeal in this case gave important guidance on the assessment of claimant's injury where there are multiple causes. Ms. Kozak was a secretary for BAE for almost 20 years, and in 2006, after a particularly difficult meeting, her line manager said that women take things more emotionally than men. That comment was the final straw in a series of stressful events for the claimant. At the first instance ET, that comment and her subsequent dismissal were found to be acts of sex discrimination. And following protracted proceedings, the claimant was awarded £360,000. The Court of Appeal held that there were 2 appropriate ways to reduce the compensation in cases such as Ms. Kozak's. Firstly, where an injury has multiple causes, the tribunal should attempt to apportion liability accordingly, but only if the injury is divisible. This would be in situations where the employer's wrongdoing exacerbated or accelerated a pre-existing illness. Would be situations where an individual had a pre-existing vulnerability or disorder, and it was appropriate to reduce compensation to reflect the possibility that the individual would have suffered harm absent the employer's unlawful conduct. The Court of Appeal found that even though Ms. Kozak's injuries may have been caused by multiple factors, they were not divisible. Taking then this issue 3 about divisibility and indivisibility of harm, before going through the final case of Olalemi, I'm going to deal with this distinction between divisibility and indivisibility of harm. The leading authority in this case is Rahman and Air Rose Limited. In that case, the claimant was assaulted in a fast food restaurant in which he worked and suffered a serious facial injury. His employers were held liable in negligence for not putting in place sufficient protection. His injuries were negligently treated in hospital, and he became blind in one eye, unfortunately. He also developed a serious psychiatric illness. One of the issues was whether the psychiatric illness and its consequences should be regarded as the same damage. The important takeaway from Kozak and from Rahman was as follows. The tribunal should seek to find a rational basis for distinguishing between a part of an illness which is due to the employer's wrong and a part which is due to other causes. But whether that is possible will depend on the facts of the case and the evidence. If there is no such basis, then the injury will indeed be truly indivisible, and principles requiring the claimant if there's no such basis, the injury will indeed be truly indivisible, and principles require that the claimant is compensated for the whole of the injury. Though importantly, if the claimant has a vulnerable personality, a discount may be required. Olalemi and Athena Medical Centre is the final case in this section, and this is a 2016 decision where the claimant, who had worked as a GP for the respondent from 2001 to her dismissal in 2008, was subsequently diagnosed with PTSD. Her claim of sex discrimination, unfair dismissal, and breach of contract were upheld. She'd suffered a previous PTSD episode in 2003. The claimant was awarded over £750,000 for her claims. The East London Tribunal reduced the whole of the claimant's losses caused by PTSD by 12.5%, on the basis of a report which suggested that the 2003 PTSD episode had contributed to the causation of the 2008 episode of PTSD. The total award was made up as follows: £30,000 for injury to feelings, including £5,000 in aggravated damages, £21,000 for personal injury for the psychiatric conditions, and a combination of around £400,000 for past and future losses. The claimant's appeal against the blanket reduction of 12.5% was allowed and the issue was remitted. The EAT found that the Employment Tribunal had not explained why it considered the previous episode of PTSD to have been a material cause of the present episode, as opposed to merely rendering the claimant vulnerable or susceptible to a further episode. In any event, the Employment Tribunal had not considered how the loss should be divided. A blanket reduction of 12.5% simply couldn't be justified. On the issue of divisibility and indivisibility, the EAT said as follows: it's open to the respondent to show that there was another material cause for the claimant's psychiatric condition. That is, a cause going beyond mere vulnerability or susceptibility. Even so, it's not a defence for the respondent to say that there's another material cause for her psychiatric condition, unless the resultant harm is truly divisible. If, however, the resultant harm is truly divisible, the tribunal concerned must estimate and award compensation for that part of the harm for which the respondent is responsible. In so doing, it will apply the tortious measure of damages. It will identify the harm for which the respondent is responsible and award compensation for that harm, as opposed to harm which would have occurred in any event. Sarah, back to you.
Thank you, Grace. Okay, so I'm now going to deal with what forum to bring personal injury claims in, because of course you can bring them in both the County Court and the Employment Tribunal. Now, generally, if a claimant has a discrimination claim and they have suffered some form of injury, what they tend to do is tag it on to the Employment Tribunal claim. However, is there any reason why you might consider doing it slightly differently and bringing it in the County Court? Now, obviously, you cannot bring a discrimination claim arising out of employment in the County Court. You can bring a negligence claim, and clearly there are many situations in which there's going to be quite a lot of overlap between the facts that would give rise to a discrimination claim and a negligence claim. So, for example, in a failure to make reasonable adjustments. You could also have a harassment stroke bullying type situation. Now, if it was being alleged that was on the ground of, say, race or sex, that could form a discrimination claim. But of course, in the County Court, you could simply bring it as a general breach of duty, failure to protect, that type of claim. So, one really important factor to bear in mind when considering what to do is the fact that in the County Court, you have the benefit of not having to show any link between a protected characteristic and the injury that followed. So, for example, in the bullying example I've given you, a tribunal might well find that certain comments or acts had been done which were inappropriate, unfair, or so on, but they might find that actually they had nothing to do with the claimant's race or sex or whatever it was, in which case you would fail in a discrimination claim. However, that could certainly give rise to a negligence claim. Of course, you'll all be familiar with the colloquially known bastard defence in discrimination claims, which is that effectively, I treat everyone badly. It's got nothing to do with the fact you're a woman. You wouldn't have to worry about that in a county court. Now, if you've got a very high value personal injury claim, which is going to be really complicated and which actually is where the bulk of the damages are going to be, because it's effectively going to be loss of earnings for the rest of one's career. And that's got to be linked to the PI element. You might think, well, actually, is the county court going to be my preferable place to do this because of the fact that they will be more regularly dealing with these types of complicated issues. Also, big factor to bear in mind is costs. Now, that could go either way, depending on whether you're the claimant or the respondent. If you've got a potentially high value claim, which in the employment tribunal, the claimant did not have the funds to pay for, and the only option was potentially trying to find someone who would do it on a CFA, could you formulate the claim in a way that would give rise to negligence? Another important factor, of course, is the difference in time limits. We obviously have very strict time limits in the employment tribunal. And if you have an individual who has got very severe mental health problems following, say, a dismissal, you might find that in the very short 3-month periods following dismissal, they are simply not in a position to be able to give detailed instructions to bring a claim. And their only option might therefore be trying to formulate it in such a way as to bring it in the county court, because of course they're going to have 3 years. Now, downside to bringing claims for personal injury in the county court is how the phrase "in the course of employment" is interpreted in different spheres. Now, in the case of Jones and Tower Boot Company Limited, 1997. Now, this was a claim under the Race Relations Act, and the Court of Appeal found that actually that phrase in that context should be interpreted by reference to the ordinary meaning of those words, rather than by the more stringent requirements of the common law test of vicarious liability. Well, the facts of that case were that the employee was of mixed ethnic origin, and he was subject to some appalling acts of race discrimination, such as being called chimp and monkey, having his legs whipped, and having his arm burnt with a hot screwdriver. Effectively, the employer's argument was this couldn't be seen as being done in the course of employment because the acts were of such an extreme nature. They relied on the common law case law, which effectively said that the employer is liable for acts which he has not authorised if they are so connected with the act that he has authorised that it may reasonably be regarded as a mode or improper mode of doing them. And the Court of Appeal disagreed with this. And what they said was, you need to bear in mind the purpose of the legislation under which the claim is being dealt with. Because this was being dealt with under the Race Relations Act, it had to be borne in mind that this act was not simply enacted to compensate victims, but it was also there to ensure that discrimination was eliminated. So therefore, it would actually be easier to pursue claims in the employment tribunal based on the actions of one's colleagues, even when those actions were extreme, because one is applying a different interpretation to the very common phrase of in the course of employment. Now, one matter which is quite an interesting one to consider is, could you bring claims in both forums? So say, for example, you started a claim in the tribunal, and could you later bring a claim in the county court, which arose out of the same facts? Yes, say you were to lose a discrimination claim on the basis that one couldn't make out the causal connection between the act and the protected characteristic. Now, of course, you are no doubt going to be met with arguments relating to abusive process, finality of litigation, and no doubt a defendant will vehemently argue that you shouldn't have a second bite at the cherry. However, what about the situation when you would be pursuing entirely different causes of action? So, for example, if you were to bring, say, a race discrimination claim with a PI claim tagged on in the employment tribunal and you lost, could you then seek to bring a claim in the county court, assuming you were still within time, for negligence? Because of course, you cannot bring a negligence claim in the tribunal, so you have a different cause of action. Well, potentially, yes, you can, because this is exactly what happened in the case of the University of London and Tariq Zaman, a 2010 case. Now, here, the individual had brought a claim in the tribunal. It was based on an alleged agreement by the university to appoint the claimant as a doctor to a particular post. And he said he was told that he would not have to go through a competitive interview. The university then went back on that and required him to attend one. And he said this was direct race and sex discrimination because the person who then got the job was female and of a different race. His claim was struck out. Effectively, the tribunal could not find any connection between his treatment and his race or his sex. However, he then brought a later breach of contract claim in the High Court. Now, it arose out of the exact same facts. And unsurprisingly, the defendant argued that it was an abuse to bring such a claim because effectively those same facts had already been subject of determination by the employment tribunal. However, the High Court disagreed with this. And effectively, they said, well, there is an important distinction between these two claims. They are different causes of action, and the outcome of one would be in no way determinative of the other. So if we look at this in the personal injury sphere, you could have a negligence claim for failure to look after the health and safety of an employee, which could succeed, and you may simply not be able to succeed in a discrimination claim because it might well be that there was no connection between the treatment and the characteristic relied upon. So in that scenario, it could well be the case that you could seek to bring the claim later in the county court. Now, of course, have to be very careful about that because you're almost always going to face an argument that it's an abusive process. But if it's a very high value claim and the claimant has the funds and wants to pursue it, you could find a way around it, especially if you have helpful findings in the tribunal as to the conduct of the employer. You could seek to rely on them to bring the further claim. Okay, so I'm going to go back to Grace now, and she's going to touch on some of the things to be aware of if you are considering employment tribunal and county court claims.
Thanks very much, Sarah. And I've seen we've had a question actually about this case that I'm about to deal with. So listen up, whoever's asked the question. The final issue I want to deal with is where you've got a separate PI claim in the county court after the ET claim is finished, and the risk of potentially compromising that personal injury claim, obviously bearing in mind everything that Sarah has already said. This is the case of Akai and Newcastle University, which actually reached the Queen's Bench Division in May of this year, presumably via CBP or Cloud. Professor Akai appealed the decision from Newcastle County Court the previous May, striking out his claim for personal injury, specifically PTSD, allegedly caused by breach of contract, breach of duty, and or harassment. And that claim was struck out as an abusive process by the judge who heard it in the county court. The claimant had commenced employment with the defendant, obviously defendant in the county court, at Newcastle University in 1998, and his employment had continued until September 2013. Professor Akai had brought a claim in the Employment Tribunal in December 2013, alleging two separate and distinct sets of claims. Firstly, unfair dismissal and direct age discrimination, which were referred to as the dismissal claims, and claims spanning the period of 1999 to 2004 and 2010 to 2013 of age, race, and religious discrimination, harassment, and victimization. Those are referred to as the harassment claims. His claims before the county court arose out of essentially the same factual matrix, and his claims before the employment tribunal did not include a claim for personal injury. The harassment claims, so harassment, victimisation, race, religion, and part of his age claims, were struck out by the tribunal for failure to comply with tribunal orders to provide proper particulars. And it sounds like very repeated failures to provide those particulars. It was struck out as an abusive process. His remaining claims before the tribunal were therefore unfair dismissal and direct age discrimination. In July 2015, the claimant solicitors wrote to the defendant confirming that they'd been instructed to pursue a personal injury claim, and this was whilst the employment tribunal proceedings were ongoing. A claim was issued on the 25th of August 2015 at Newcastle County Court for personal injury. The employment tribunal claims were settled on the 27th of August 2015, so some 2 days later, for £65,000. It sounds like some sort of judicial mediation took place, and that's how that figure was arrived at. The claim form in the county court proceedings was not served on the defendant until the 3rd of September, so a few days after the claims in the employment tribunal had been settled. His particulars of claim was served on the 28th of May 2016, and the defendant's defence was filed on the 19th of September 2016. An application to strike out on the grounds of res judicata and or abusive process was not sought by the defendant's solicitors until the 28th of November 2018, so almost 2 months after 2 years after the defence had gone in. It seems to me from having read the case that the reason why there was such a delay was that the issue was going to be dealt with as a preliminary issue at the start of the trial, but then for various reasons, the application went in when the original trial was supposed to be listed. His Honour Judge Gargan rejected the claimant's contention that the settlement agreement precluded the defendant from seeking to strike out the claim as an abusive process or res judicata. So the claimant had been trying to say that the settlement agreement prevented the defendants from even making this application. His Honour Judge Gargan did, however, strike out the claim in the county court as an abusive process, but he held that the claim was not res judicata. The judge dealt with the abusive process argument and held that as the harassment claims had been struck out in the employment tribunal as an abusive process, the county court action should be struck out unless there was some special reason not to do so. His Honour Judge Gargan identified 3 reasons why someone might not pursue a claim for personal injury as part of an employment tribunal discrimination claim. And those 3 reasons would firstly be ignorance, in the sense that the claimant didn't know that they were able to pursue a claim in the employment tribunal. Secondly, a deliberate decision not to advance the claim in the tribunal. And thirdly, where the injuries had not yet come to light, or possibly where the true extent of the psychological symptoms had not yet been properly understood. However, in this case, Professor Akai provided a witness statement where he'd made reference to his deliberate decision not to bring a PI claim in the employment tribunal, but didn't really explain why that was the case. On the issue of the settlement agreement, the Queen's Bench held that the compromise agreement itself did not prevent the claimant from pursuing the PI claim. However, there was no agreement, express or implied, that the claim was an abusive process. The compromise agreement only settled the dismissal claims, since the 2013 harassment claims, which should have included the claimant's personal injury claim, had already been struck out. The defendant, having already applied for those claims to be struck out once, the claimant essentially should have expected that a strikeout application would have been following again. I think this case is a real warning to claimants not to prejudice themselves in county court proceedings by failing to comply with tribunal orders and ending up with abusive process as the outcome. And it's also a reminder to respondents and defendants to consider abuse arguments if they find themselves in a similar position to that of Newcastle University. I think it's also important to note that the decision in this case appears to be very fact-specific. The claimant's claims upon which he should have pursued his PI claims were struck out as an abusive process for not properly particularising his claims. One could have thought that could have been avoided by complying with the tribunal's orders. But it's critical that where someone is choosing to pursue parallel proceedings in both civil courts and the ET, they and their advisors must be alive to the risk of strikeout. There are, of course, as Sarah identified, some estoppel issues if the claim proceeds in the ET and a judgment is promulgated in that forum in any event. I think we've now got a few minutes for some questions. I know we've had quite a few come in. Sarah, I don't know if you've had an opportunity to look at any that have arisen so far.
I have, thanks, Grace. Yeah.
The same.
Yeah, so one that I think is relevant to what I've just been talking about, which is the question as to can you reserve your position on a PI claim and forum until you have judgment on liability in the employment tribunal. Well, yes, you can. Should caveat that with, it does not necessarily mean that you therefore won't face any problems going forward, but it certainly is something that if you're raising it from the outset would be relevant when considering an abuse argument. In the case I referred to, University of London, the claimant had not reserved his position on a breach of contract claim in the county court, but the judge there found that that didn't matter. So even if you don't do it, it doesn't necessarily mean that that would be a bar, but certainly it's something that would help you. It's going to depend on the facts of your case. Grace, I don't know if there's anything.
Yes, I was just having a look at the question about the particularisation of the personal injury claim, whether it should be essentially particularised in the level of detail you might expect to see in the county court, or whether it's sufficient to add as a claim for losses due to PI in the schedule of loss. I think if I was drafting a particulars of claim, I'd raise it in the particulars of claim. I don't know if I'd go into the amount of detail that you would if it was a separate claim in the county court, but I certainly wouldn't just have it in the schedule of loss. I think I'd particularise it in a fair amount of detail in the particulars of claim in the ET.
Yeah, I mean, I'd agree with that. Technically speaking, it isn't a separate cause of action in the tribunal. It is a remedy flowing out of your cause of action for discrimination. However, I have certainly had arguments from respondents that if it's not referred to in the grounds of complaint, it's not been properly pleaded. And I think, technically speaking, you probably don't need to, but there's no point setting yourself up to have to face to defend such arguments. So yes, certainly put it in the grounds of complaint. Generally, it doesn't need to be put in that much detail. A couple of sentences saying, and the claimant suffered personal injury in the form of anxiety, low mood, and depression, or something along those lines is generally sufficient.
Agreed.
Okay. And so I'm just having a little look through any other questions.
Just having a look at the question about claiming PI for more than just disability discrimination claims. I mean, a lot of the ones that I touched on today have been sex discrimination claims. That's something that, and clearly also race discrimination. I think Sarah had a case on that. Whether you can claim PI in circumstances where there's automatic unfair dismissal claim due to whistleblowing. I think I can remember that I did read that was possible, but Sarah, I don't know if you have any specific case law on that, or whether you think that's right, that you can.
No, I don't have a specific case. Obviously, unfair dismissal you can't, and there's a whole load of cases on Johnson and Unicy's exclusion zone and issues with that.
What I'll do is I'll have a look at that point and come back to the person who asked the question just to confirm.
I don't think I can see any more. We had a couple in advance, but I think hopefully those who put the questions in advance, they were dealt with in our talks today.
Yeah. Perfect. Okay. Well, thank you everyone for attending, and thank you very much for supporting 3PB and all of the events we've done throughout the course of this year. We'll be in touch with details of our 2020 events in due course.
Thank you all. Goodbye.